Hey, good morning, everyone, or good evening, or good afternoon, wherever you are. So my name is Vijay Ramjattan, and I'm a graduate from the University of Toronto. And today I'm going to be talking about racializing accentism in the workplace. So in terms of giving you a formal definition, sadly, there isn't any one coherent or widespread definition of accentism. However, I do like this one that's provided by the Accentism Project, which is a website dedicated to raising awareness about and fighting against accentism. So for them, accentism is, quote, any situation in which an individual feels as though they have been unfairly judged, treated, or commented on because of the way they speak, write, and communicate more broadly. So if we just think about speech accents today, accentism really exists because we tend to link the sound of people's voices to a series of higher order traits, right? So depending on a person's accent, we can judge their friendliness, their credibility, their attractiveness, their employability, and even their professional competence, among many other things. Given the ubiquity of oral communication and transnational migration in late capitalism, accentism is especially pronounced in the context of work. In fact, since accent can be treated as a bona fide occupational requirement, or B4, it becomes acceptable to disparage workers on account of their accent. So if a worker has a so-called foreign accent and they experience discrimination in the workplace, this discrimination can be framed as really more about constructive criticism, about not being able to do their job, right? Which might require a lot of talking, for example. One issue with the discussion of accentism at work is that it tends to treat it as some type of new or independent form of oppression, something that's divorced from other types of oppression in society. However, today I want to argue that accentism is really an auditory manifestation of workplace racism. Moreover, I want to argue that accentism doesn't simply occur at the level of bias in interpersonal encounters, right? So it's more than just individual perceptions, it's more than just individual behaviors. Rather, accentism is a type of institutionalized racism that sustains racial hierarchies in white settler nations such as Canada. So in terms of an agenda, I have to be honest, I have a very modest agenda today. So my intent is not to give you a comprehensive overview of accentism. Rather, I hope to pique your curiosity about the topic, and hopefully you'll reflect and maybe further research the topic after the conference. So with that said, I'll just talk briefly about accentism as a type of racialized hiring. Then I'll talk about it as a type of racialized training. And then I'll just briefly consider ways that we can combat accentism in the workplace. So let's talk about accentism as a type of racialized hiring. So you'll see many studies showing how employers will sort of judge so-called white accents as more employable than accents coming from racialized bodies. But one maybe issue with these studies is that they tend to be experiments, right? And people may argue that they don't really capture real employer behavior, right? But one nice counterexample to this argument is a study by Philip Oreopoulos. And so in his study, even though it was an experiment, he actually interacted with actual employers. So Oreopoulos' study, which was looking at why skilled migrants struggle to find work in Canada, is really a useful example to highlight how race gets tied to accent in hiring and how this connection is maybe more widespread than we would like to believe. So the study basically involved him sending 13,000 mock resumes to over 3,000 job postings in the Greater Toronto Area, which is a part of Canada which receives the most skilled migration in the country. One interesting finding from the study was that despite having favorable qualities, such as degrees from top-ranking schools and relevant work experience, Oreopoulos found that in general, resumes with Indian, Chinese, and Pakistani names received less callbacks than those with Anglo or English names. In follow-up interviews with employers to whom the resumes were sent, he found that employers saw an Asian name or a South Asian name as indicating that an applicant would have a so-called hard-to-understand accent, right, which would interfere with professional communication. And this was actually in spite of the fact that some of the resumes highlighted how applicants completed higher education or had prior work experience in Canada. So this might suggest that some applicants had a so-called Canadian accent, or at least they had a an understandable enough accent for them to be able to work and study in Canada already. So in the end, Oreopoulos highlights how accents, seemingly tied to racialized bodies, can override professional experience, credentials, actual qualifications when determining employability. And once again, so just to repeat, the fact that Oreopoulos interacted with actual employers and his study was a fairly large-scale study, it gives us a sense that accentism as racialized hiring is maybe something that's more prevalent than we would like to admit in Canada. So I've talked about accentism as a type of racialized hiring. It's also important to know that accentism forms the basis of much racialized workplace training at the same time. An infamous example of this is transnational call center work. And in this context, racialized workers learn about the so-called deficiencies of their speech for white audiences. So as scholars like Kiran and others have mentioned already, right, your typical Indian or Filipino call center worker might have to take these so-called accent neutralization courses or these intercultural communication courses to learn how their style of communication is really, or is allegedly deficient, right, when interacting with white callers from the global north. When we talk about accentism as racialized training, it's also important to know that accentism really creates an entire industries. And one such industry is the so-called accent reduction industry that you see in Canada and basically any other global north country that receives a lot of skill migration. So accent reduction programs are basically employment programs for skilled migrants. So they operate on the premise that because migrants have these hard to understand accents, the only way for them to become more employable is to reduce their accents, right? And make them more attractive for employers in the job market. There are many problems with accent reduction programs, but just one such problem is its tendency to attract racialized people as potential clients. So you never see ads for white British speakers of English, for example. They're typically geared towards migrants from the Caribbean, Africa, Asia, and so on. Another major problem with the accent reduction industry as a whole is that it tends to use accent to reinforce, normalize, and visibilize racist structures in our society. Specifically, the way that accent reduction advertises itself reinforces the same narrative of fixing oneself rather than fixing or dismantling the system that causes oppression in the first place. And this point is exemplified in this ad that we have from a company called Change Your Accent, and I believe they're based in Vancouver. So what I'm going to do, I'm just going to read this ad for you, and then I'll briefly talk about the problems of it. So it says, if we don't promote someone because they are difficult to understand, yet are hesitant to talk about accent reduction because we think it's discriminatory, aren't we simply ignoring the elephant in the room? By avoiding an issue which can have a profound impact on the individual and the company, are we really achieving a workplace that doesn't discriminate? If someone is struggling with communication at work and missing out on promotions, isn't a conversation about accent reduction really about empowering employees? So at first glance, this ad is making the argument that accent reduction is about empowerment. So if employees are experiencing discrimination on the basis of their accent, they really have to become this neoliberal entrepreneurial subject and vocally change themselves, and then allegedly this discrimination will magically disappear. But if we look a little bit deeper into the ad, right, there are many problems to address, right? So just this idea of how accent can have a profound impact on the individual and the company. So my counter question to this is, why is accent made relevant in the workplace or in organizations, right? Is the problem really the accent? Is it really the perceptions of employers and coworkers with regard to the accent, right? How are these perceptions maybe embedded in organizational processes and institutional practices in the workplace, right? So Change Your Accent never really addresses this. Another problem that it doesn't really address specifically in the ad, but what we can think about in general is this idea of accent reduction being able to make oneself magically employable, right? So it doesn't really address how there are structural issues that particularly disadvantage racialized migrants, right, in Canada and elsewhere. So if I don't have Canadian work experience, for example, how is changing my accent going to make that problem disappear, right? If my credentials aren't being recognized by various regulatory bodies, how is my accent going to make my credentials be recognized on the job market? So change your accent, the accent reduction industry as a whole, makes employability an issue for the immigrants to deal with and not with society or institutions. Okay, and how am I with time, okay? Yeah, okay. So just quickly, just thinking about ways to combat accentism at work. So just going back to my previous point, the racialized nature of accentism highlights that the suppression can't be dismantled through individual behaviors, right? So it's not about just changing your accent and then discrimination will magically disappear. It's really about structural changes, right? So I'm talking about dismantling white supremacy. I'm talking about dismantling settler colonialism. And obviously these are easier said than done. And that's something that we all have to figure out on our own activist journeys. However, on the micro level and in the meantime, I would say one way to combat accentism at work is really learning how to listen in the workplace. So when we talk about workplace miscommunication, we tend to place the blame or the burden of communication on the stigmatized accented speaker. And we never consider how our own perceptions of the speaker actually contribute to misunderstandings in the workplace, right? We never consider how our ears are conditioned by ideologies of white supremacy and other ideologies of oppression, and how this conditioning actually creates misunderstandings in the first place. So when I talk about learning to listen, I'm not talking about learning as a sort of individual technical skill that each employee has to master. I'm talking about a collective listening, a collective learning, a collective action plan that addresses how we listen to accented speakers, really relies on these ideologies of white supremacy and other ideologies of oppression. So yeah, this listening has to be has to involve some sort of anti-racism training on the micro, meso, macro level, because as I've hopefully shown today, accentism was and is never about accent alone. Accent is really a micro level means to sort of reinforce all of these ideologies and structures of oppression that we have today. So with that said, I'll say thank you very much for listening. So, yeah.
Okay, thank you, Vijay. Well managed. So you use about 12 minutes to finish.
Okay, great.
Excellent. Okay, so the next presentation is by Mia. So prolonged working lives, old workers, and dismissals. So over to you, Mia.
Sorry, I just wanted to to find. Can you hear me now?
Yes, I can.
Yeah, you can hear me now. Thank you. So thank you very much for giving me the opportunity to present this new research project of mine on prolonged working lives, older workers, and employment protection. So I have no specific research results to report as of yet, but I hope to provide you with the context and the research perspectives and questions of this project. So to set the scene, the project starts from the ongoing challenges relating to an aging population. An aging population is a major trend in the EU, as in many developed economies, and this has a connection to declining birth rates and rising life expectancy. And the challenges to society are manifold. So it relates to economic performance, intergenerational solidarity, social cohesion, and also the sustainability of pensions and healthcare systems. And there are specific challenges for labor law, which is my area of research, as well as for industrial relations and collective bargaining. So in this area, we have seen in recent years an expansion of non-discrimination law, protection of new grounds in new areas of society, new measures, but we still see a lot of ageism in the workplace and actual discrimination on grounds of age of older workers. We have also seen an employment protection system and employment protection law under strain. My perspective is the Swedish context, so I will here provide the Swedish and the European perspective. And we start from a labor market situation where older workers fare relatively well. In Sweden, there is a high employment rate for older workers, and the average retirement rate is about 65 years. Still, considering the challenges of the aging population, there is a need to prolong working life. There is a need to adapt work and the working environment, and the need to combat, as I said, discrimination and provide protection for these basic fundamental rights of non-discrimination. This research project was construed last year, and then the COVID-19 pandemic has hit. And I will turn to that later on in the presentation, what kind of factors or developments that will impact specifically on older workers. So I'm trying to change my slide, but it seemed to have.
Or you can try the arrow,
Yes, I'm trying with the arrow. So thank you. Now it works. So the basic research question of this project is, to what extent does the legal protection in dismissal situations enable or hinder older workers to keep their employment and thus contribute to the general promotion of prolonged working lives? And we study legal protection provided by employment protection, non-discrimination law, and collective bargaining. We focus on the Swedish case and Swedish law within an EU and comparative setting. And Sweden is a member state of the EU, and thus EU law is both superior to Swedish law and an integral part of Swedish law. Our perspective is, as I said before, labor law, but we apply a socio-legal approach and include industrial relations perspectives. And importantly, we will do case studies of collective bargaining with the semi-structured interviews with social partners to see how collective bargaining interacts with the legal framework. We will also conduct a comprehensive analysis of case law from the Swedish Labour Court in order to be able to explore what kind of protection that is actually provided for older workers. We will focus on 3 specific cases. We will look at dismissals for personal reasons, dismissals for redundancy reasons, and compulsory retirement. I know that in many countries, compulsory retirement has been abandoned exactly due to its age-related component or discriminatory component. But in Sweden, it still exists a system of compulsory retirement. We will conduct an integrative research approach and study the interplay between the 3 different legal frameworks: employment protection law, non-discrimination law, and collective bargaining. And we want to inquire if these 3 distinct systems of legal protection actually serve to mutually reinforce each other, or if they maybe are actually conflicting and putting the older worker in a less fortunate or less protected position. If we turn first to the legal framework of employment protection law, for any labor law system, this is a core and very often debated area of labor law. In the Swedish case, it's regulated in national legislation, in EU regulation, and in international regulation. There is, for example, an ILO Convention on the Termination of Employment. If we look towards scholarship in employment protection, or the discourses underlying the legal developments and the legal provisions, we find a number of different, partly conflicting discourses. Employment protection is understood as protection against arbitrary dismissals. It can be understood as protection for the weaker party and older workers being specifically weak or vulnerable. It can also be discussed in terms of economic efficiency, providing or prohibiting economic efficiency. And a related discourse is that of flexicurity and flexibility, a balancing of flexibility and security. And in recent years, there has been increased emphasis on the human rights discourse. And in the EU, this is linked to the adoption of the EU Charter of Fundamental Rights and its Article 30 that provides employment protection as a fundamental right. Otherwise, at EU level, there is only partial regulation of employment protection, still national variation, And post the global financial crisis, we have seen massive austerity measures and deregulation in very many member states. If we look to the Swedish case, we have an Employment Protection Act that was created in 1974 and a very strong just cause requirement providing protection precisely against arbitrary dismissals, particularly when it comes to personal reasons, dismissals for personal reasons. However, in redundancy situation, there is great respect for managerial prerogative. And here we also see that collective bargaining and trade union consultation works to both enable and also mitigate the consequences of restructuring. In recent years, we have had an interesting political development in Sweden where the government, constituted by the Social Democrats and the Green Party, had to make a compromise, the January agreement, with the Liberal Party and the Centre Party. And this January agreement has targeted precisely employment protection and suggesting deregulatory reforms. So this is a contentious area at the moment in Sweden. When we turn to the legal framework of non-discrimination law, we find a lot of EU law regulation. This is a very strong area of EU law with both so-called primary and secondary law. We have fundamental rights, human rights to non-discrimination on grounds of gender, but also of many other different discrimination grounds, including age and disability. So in EU law, there is a ban on age discrimination, which has been implemented also in Sweden as a member state. But age discrimination differs from other discrimination areas. And there are many examples in the workplace and in the labor market of direct and indirect age-related regulation. And this is enabled by a large scope for justification of age-related treatment and specific exemptions, and also a broad margin of appreciation afforded by the Court of Justice of the European Union for the member states and for social partners. An important area, of course, to advance the protection against non-discrimination law in general, but also protection for older workers, is multiple and intersectional discrimination. And here we can conclude that EU law and Swedish law is not very advanced in terms of legislative provisions or case law protections. So this is still an area to expand, even though we know that in practice there are many important multiple and intersectional discrimination aspects. In Sweden, the regulation is provided in a specific act, the Non-Discrimination Act. The third protective framework or legal framework is collective bargaining. And here there is a great difference between the Swedish system and the system in many other countries. We still have a very strong emphasis on collective bargaining, on autonomous collective bargaining, and a broad coverage of collective agreements. Actually, 90% of employees in Sweden are covered by collective bargaining agreement. And most legislation can also be deviated from by way of collective bargaining. The Swedish system is one of so-called organized decentralization. So we have local and also individual bargaining, but always within a strong and stable national sectoral bargaining framework. Even so, we see in recent years some challenges to collective bargaining, and perhaps the most important challenge coming from legislation and from the government and the parliament wanting to interfere with the tradition of autonomous collective bargaining. We have seen this in the employment protection area. A few words on the COVID-19 pandemic. Of course, it has provided lots of important economic, societal and political challenges apart from the global health crisis that it constitutes. An important challenge is to the core of EU solidarity and coordination. In the pandemic, to a large degree, each member state has fared for itself, intervening with the core principles of free movement and solidarity. The Swedish policy is perhaps known to you as a policy standing out. It's not a policy of full lockdown, but a policy of recommendations from the government and from authorities, a policy of social distancing, decrease in public activity, and an emphasis on telework. We have seen extension and strengthening of social security systems such as unemployment and sickness, but we have also seen already and are expecting even more far-reaching implications for the labor market, restructuring, short-time working schemes, layoffs, and dismissals. So already we have seen what we see in other countries: increased inequality, increased polarization. The most vulnerable and precarious workers, they have already suffered the most, as have employees in risk groups. So of course, in our project, we must also see how this will impact on older workers, and also if this may increase intergenerational tension as younger workers are particularly hit by the COVID-19 pandemic, as also the work by the ILO has shown on a global scale. So just to conclude with highlighting the 3 different cases that we will study, as I said, through legislation, through case law, and also through collective bargaining studies. We will look at dismissals for personal reasons. A basic principle in Swedish law is that sickness or old age can never justify a dismissal. It could never constitute just cause for dismissal, but still we are uncertain if this is really and truly the case if we look to the empirical realities today. We would like to study how age, sickness, and disability interact or interrelate, and how requirements for work environment adjustment, rehabilitation, and reasonable accommodation actually serve to reinforce or conflict with each other. When it comes to redundancy reasons, it is always just cause for dismissal, but there are important so-called seniority rules, principles of last in, first out, actually indirectly age-related provisions, and we would like to study how these are interpreted by the courts and also applied in practice in collective bargaining. Are older workers provided extra protection, or are they negotiated out from the workplace in terms of restructuring? And lastly, we would like to look at compulsory retirement. There was a case in the Court of Justice of the EU, the Swedish Rönnmar case, that actually accepted the Swedish system, and it was found to be within the framework of justified age-related measures in terms of the non-discrimination legislation. But still, we would like to see how this is actually implied and if there are any changes to expect in the future. So thank you very much, and I look forward to future questions and discussion.
Thank you very much, Mia, for this very in-depth explanation of the Swedish law. Our next presentation is the failures of the colorblind employment standards enforcement regime in Ontario. Kiran and Sheldon, over to you.
Thank you very much. Yeah, thank you all for this really incredibly rich session. Sheldon and I are both at OISE. Sheldon is a doctoral student at OISE, and I teach in the Adult Education and Community Development Program. And we've both been involved in this project for several years. It's a collaboration led by Leah Wasco at York University, and also by Mary Gallatley, who's at Parkdale Legal Clinic, and involves very closely work with the Workers' Action Center. So this is actually a project that focuses on employment standards enforcement in Ontario. And we're going to present to you a small slice of this project. Particularly, I guess what we're hoping to do in our few minutes today is to give you a bit of background on the rise of precarious employment. We're going to talk a little bit about the racial stratification in the labor market in Ontario, and then we want to talk about the failures of the colorblind enforcement regime. You know, Sheldon and I will kind of divide the presentation. as we go along. Okay, so there's been lots of literature on the very rapid rise of, precarious employment within Ontario, within Canada, and actually globally as well. And, this is basically employment that is poorly paid, often contract, short-term, where people don't have sufficient protection against employers who are violating the law. There have been many studies which, document this rise. So, for example, this is a study by Wayne Luchek's team, and, it really documents how much precarious employment has in fact, grown for both women and men in these last few years. Another sort of study which very clearly documents this is in a report called The Color-Coded Labor Market by Block and Galabuzzi. And you can see this work as well as their future work, that systemic racial discrimination is both like a demographic and an ideological concept. So, really shows very clearly that racialized Canadians are overrepresented in a range of low-paid industries, call centers, security services, janitorial services, and really this ends up leading to an earnings gap and, really stark evidence. Things like immigrant women earn less than half of what non-immigrant men earn. And, really also goes together with immigration because shows that recent immigrants to Canada, a majority of which of whom are racialized, are likely to be employed in part-time jobs, even though they'd prefer to work in full-time jobs. This also disadvantage of newcomers occurs across educational levels. I guess this idea that, a lot of people now work in survival jobs, and that, as Mark Thomas, one of the people who's involved, one of the researchers at York involved in this team, has really written that precarious jobs are disproportionately held by workers of color, whether recent immigrants or Canadian born. And it's these workers who are most directly affected by inadequate employment standards, right? So I guess, our interest was really in these employment standards. So some of you might know that we have in Ontario on employment standards law and similar law in other provinces. And really this law sets out the minimum terms of employment. This is around wages, around working time. It sort of sets the minimum floor of rights in practice, right? But in fact, what has happened is there's a numerous sort of industry-specific, job-specific exemptions and special rules that have ended up being in place. So, these exemptions end up applying to sectors where racialized people and immigrants are really overrepresented. So, give you a couple of examples. 80% of workers in the accommodation and food services sector are precariously employed. Large proportion immigrant and racialized workers, but many of these workers are in fact exempt from certain ES employment standards provisions. Home care workers, for example, are exempt from provisions related to hours of work, breaks, overtime. Servers and establishments withhold liquor licenses, they're exempt from receiving minimum wages. So really, I guess the exemptions that are in place have a very negative effect on racialized workers in particular. And I guess this is what we generally call the enforcement gap. And that is the gap that is sort of, this is the book from the project that's recently come out, but it's really about the fact that employment standards largely follows what one can call a compliance model, where violations are sort of seen as exceptional, occasional practices that employers may sort of engage in. the focus is really on, trying to catch a few of those, sort of employers that engage in these practices of violation. Even though, there's so much evidence that in fact shows that this is kind of almost a way of doing business, engaging in these kind of like unfair labor practices. But there's very little accounting in the way in which employment standards law is enforced for the structural ways in which, racialized people are filtered into poorly paid jobs and, end up with poor quality of work. So we, in fact, in this paper argue that the current employment regime ends up reifying racial stratification. The project actually involves a fair bit of data collection, a survey, lots of interviews. And for this paper, we really focus on the interviews with racialized workers, which were done in Toronto, Sudbury, and Windsor. And this is the paper which is actually forthcoming in Canadian Ethnic Studies. So we'll just present a short couple of examples to you, but just want to give you a sense for the overall argument we make, which is basically that employment sort of enforcement fails to recognize that some employers exercise new racism, whereby through subtle and hidden practices, they foster these poor working conditions, particularly for racialized workers. And we also talk about newcomers, many of whom are racialized, and how they're in fact encouraged to use their networks to seek employment when they first come into Canada. And they often work through contemporary agencies or in small firms. And the very strong push for workers to get Canadian experience to facilitate the settlement. And these factors, these encouragements put workers in a situation where they in fact have very heightened vulnerability to employment standards violations in the labor market. And then we also talk about how, really the employment standards regime as a whole really fails to protect temporary foreign workers and, ends up reinforcing that segregation. So I guess what we're hoping to do in this presentation, we could move Sheldon to the next slide, which is what I've just talked about in terms of the three arguments that we're hoping to make. And so as for the remainder of this presentation, I guess we'll just, I'll just pass it on to Sheldon, and he'll, give you some examples from our data and also talk about some of the conclusions that we've reached.
Okay, all right, so just some examples of racialized workers' experiences. I'm gonna go through two, and Raina and Jackie, these are their pseudonyms. And Raina's example reveals a siloed approach that separates systemic racism from workplace violations. So racism is divorced. We argue that racism is divorced from the unlawful, poor working conditions and limited job alternatives that intensifies the vulnerability of racialized people. Raina is a factory worker who migrated from Ethiopia. She was unable to find employment in her accounting field. And Raina's scenario illustrates the ways in which poor working conditions are often accompanied by racial discrimination. Raina worked in a female-dominated plastics manufacturing plant for 15 years, where she reported that she and other Black workers were often given the hardest jobs. She was owed wages. She was often yelled at to the point of tears. She mentioned that she felt she was not promoted because of the color of her skin. Although she had worked at the factory, she had experience of over 15 years. But just to paraphrase Raina, she said nobody gave her a chance despite her qualifications and experience. Her employer said her English is no good, and she noted, "My English is good enough for a factory. I'm not here to write Shakespeare or something, It's for a factory job. I think I have good English, and I have an accounting background, and my experience will help the company. If I get a chance, I can make it." Raina also noted that the workplace was stratified according to race. Canadians and Europeans were treated better, followed by Chinese and Asians, and then Blacks. And Jackie's story, on the other hand, represents a failure of enforcement provisions to protect newcomers. Jackie, as a racialized refugee, had 12 years experience as a graphic designer. She struggled to find employment in her field, but through a government employment and training program, she received a placement with a small family-run enterprise in Toronto as a graphic designer. First day on the job, she was told not to steal. She was verbally abused, constantly watched, did not get paid when she was sick or worked overtime. Jackie endured the unfair treatment in the job because she hoped she could gain Canadian experience and a good reference. Unfortunately, Jackie was unfairly fired without cause and without a final paycheck or severance pay, vacation pay, and without a record of employment. She filed a complaint with the Ministry of Labour, but although the ministry eventually issued an order to pay, the employer failed to comply. Jackie didn't take the matter further, as she said, "I'm afraid for my future because I'm not a resident yet. If I make a problem, I maybe don't have the same rights like a resident or legally established like a resident. I'm a convention refugee." So some conclusions that we had in our paper is that the current employment standards enforcement regime in Ontario is colorblind. Employment standards enforcement fails to recognize
Thank you.
the connection between racism and wage theft. It also fails to challenge systemic forms of racism, and it does so by not recognizing the greater representation of people of color and immigrants in certain occupations and sectors. It fails to coordinate the settlement and career services sectors. So for instance, when Jackie reported the issues she encountered at work to the employment agency that placed her, they told her that there was not much they could do but request that the employer refrain from verbal abuse and provide breaks and etc. as required by the law. So just to wrap up, some of the ways forward are some recommendations. The employment standards enforcement should challenge the color-coded market. It should involve targeted inspections of specific sectors and industries which hire a disproportionately high percentage of racialized workers. It should extend protections for those under duress to gain local labor market experience, specifically those newcomers to Canada who are frequently told that they need to gain Canadian experience. And often this experience comes at the expense of them taking lower-level jobs. And research, as Kiran had noted before, is that these lower-level jobs that the employment standards are violated most. It should provide translation services to support workers, especially not those non-native English-speaking, French-speaking workers who wish to launch complaints and allow third-party complaints, some support to help those workers. The claims process is arduous and requires significant amounts of reading and research. So if you're not proficient in English or French, you're going to struggle to make a final complaint. Finally, it should facilitate the coordination of labor laws with policies on immigration and human rights and settlements. Because presently, Human Rights Tribunal, Occupational Health and Safety, and all the settlement laws and agencies, they are working separately from employment standards, the Employment Standards Act and the Ministry of Labour. So if these bodies were to work together in unison, that would serve to strengthen the protections for vulnerable workers. And so we just like to encourage you to read the paper. It is forthcoming in Canadian, as Kiran said, Canadian Ethnic Studies Journal. And these are some of our partners that we have had, both academic and community partners. And that's the end of our presentation.
Okay, Thank you very much, Sheldon. Thank you very much, Karen. And now we have some questions from the chat box. So the first question is from Ashnish. Ashnish, would you like to unmute yourself and speak out of your question to Karen and Sheldon team, please?
Hi, Kiran and Sheldon. We have a lot of data coming from both the US and the UK indicating the number of COVID cases and deaths among racialized workers in particular because of, as you've mentioned, the types of work they do. I'm wondering if we have any such data in Canada. I haven't come across any. It's just been anecdotal and news stories, but I was wondering if you have come across any Canadian data in this respect.
Yeah, thanks so much for that question. In Canada, we're in the very fortunate position where our news stories are actually really, some of them are really excellent and very well-researched data pieces. So we do have very clear indications that the PSWs, for example, who are on the front lines of this effect of this pandemic, negative effect of this pandemic, are predominantly people of color, women of color, actually. Also, stories like, for example, the Thorncliffe neighborhood, where it's been, one of the set of central places in Toronto where there have been many cases, and that's partly because of the situation that, many new immigrants are in, where social distancing is really not possible. And so I think we are beginning to kind of collect. I'm not sure if we have, it all in one place. It does involve compiling a little bit, but I also am, posting in the chat box a couple of the places where I found really useful reading, on this.
Okay, so the next question is from Karen to Farid. So Karen, would you please to explain your question to Farid, please?
Yeah, I really found it very interesting, Farid, your analysis. And I guess I was curious about whether you were able to trace sort of specificities of the differences between anti-Black and anti-Asian racism. And also, whether you found that there were class differences in the ways in which racial discrimination was experienced. The public sector has gone through a lot of, it's sort of a site also now of precarious labor. And so there are many people employed on very short-term contracts. And also there's a big difference when you talk about public service between managerial and the frontline, workers. So I was kind of just wondering about those differences in your sample and how you were tracing those.
Right, so the majority of participants came from, they were not dealing with precarious work or contracts that were limited term. They had, the want of a better word, stable jobs. It is just that the stability came with certain costs, i.e. them putting up with certain abuses at work. Class definitely played a role in there. Overall, the less kind of affluent the participant, the higher the likelihood was of them, and I realized this was such a small sample of them experiencing problems. I did have two participants who were very well off, and initially their perception or their perspectives were that it's really not that bad. It's just when you dig a little deeper into it is when stuff comes out. But the perspective started with it's really not that bad, and those were the only two that were well off, comparatively speaking, because I had to meet them in person. Looking at their cars and looking at the position titles, you could you could make kind of an informed a guess that it wasn't. Yeah, sorry, I don't know if I answered the full question, but they came from, precarious employment wasn't really an issue, except in the case of one of the participants. But in his, it really wasn't the nature of his contract, but the nature of his job. So when the minister, moved from that profile, he was kind of part of the political staff, and he had to move as well. But that came with the territory. It was an order in council appointment, and order in council appointments are always like that. But even then, he had a stability for at least 4 years in that job.
Okay, so just a reminder to everyone, if you would like to ask a question, and please click the button of the chat, and then there is a raise hand. So, or you can show yourself and then raise hand, I can also see you. So any questions or comments? Okay, so I have a question for Vijay. And Vijay, it's a very interesting argument for the Accentism. And may I ask, in your research, have you noticed any difference across different industries? So for example, like the IT industry and retail industry, probably they will have the communication skills may be required differently. Have you got any relevant findings related different industry about the different level of accentism?
Yeah, that's a great question. So my dissertation was looking at international teaching assistants in Ontario, and a lot of them came from engineering programs. And in engineering, there was sort of this emphasis on accent and this non-emphasis at the same time. So with engineering, there's sort of this this valuing of concise, straightforward communication. So with a lot of the ITs that I interviewed, accent wasn't a big problem except for maybe minute things like a particular sound, a particular syllable, right? But in contrast to ITs, maybe in the humanities and social sciences, there was more of a holistic requirement. Oh, okay, maybe I should change my accent because students are not believing that I'm credible enough when I'm teaching a particular topic, or they just can't understand me in general. So yeah, that's one instance where I see sort of differences in disciplines and professions in that regard.
Okay, thank you. So okay, so Mia, please.
Yes, I have a question to perhaps all the other panelists. I thought it was very interesting to hear your different perspectives, and I was wondering about being a lawyer and coming to this area from the role of law and employment relations. So what is your view on the potential of law? We heard about problems with enforcement, but what is the potential of the law? And I would also was wondering, in your system, which organizations provide protection or representation to workers being the subject of non-discrimination or racism? So is it trade unions, other NGOs? Are there any interesting recent developments in this field? I would be interested to learn more about that. Thank you.
Okay, so could we start from, let's say, Kiran and Sheldon team?
Yeah, so thank you, Mia. Very interesting. And yes, I think the law is very crucial in this in regard, because in this regard of employment standards, because it's supposed to set the minimum floor. And I guess this is our point, that when you don't have anything even setting that minimum floor, then there's a big problem, because essentially things can free fall. And that's where you're in this situation where people can actually be in very, very poor working conditions. So the law is extremely important for this field. In Ontario, it's complicated because if you're a unionized worker, you're covered by the agreement of your union rather than employment standards. So that's one already form of tension, which is a difficult position. And many of the workers in precarious jobs are not unionized, and therefore they turn to if they have support, they have support from advocacy groups like the Workers' Action Center or like the legal clinics. But then, the process of even filing a complaint is so complicated and so cumbersome that it's really difficult when you actually get down to the logistics of having to do so. Not to mention relying entirely on this idea that if something bad happens to you, it's up to you to actually file a complaint when you're in a position where you might in fact face a lot of informal reprisal. So this is part of our point. When you face racism and you face employment standards violations, they go together. Like in that story of Rönnmar, the Black worker who was really being facing harassment, racial harassment. But she had the option of going to pursue employment standards law complaints or Canadian human rights, Ontario human rights complaints. But they were all separate for her. It was a sort of a siloed approach to dealing with racism and dealing with violations, when in fact, in her experience, this was not at all siloed. She was experiencing these violations because her employer was acting in a racist way, and so legally, I suppose overall, not only is the law insufficient, but even the enforcement of that law is also insufficient. I guess that's where we come down.
And if I could add to that, in BC, when I did this study in British Columbia, the previous government, the Liberal government, had gotten rid of the BC Human Rights Commission. Now that BC Human Rights Commission is brought back, but at the time it did not exist. Instead, the responsibility was downloaded to BC Human Rights Tribunal. And the tribunal was a part of the Attorney General's Ministry of Attorney General, part of his profile. And and one of my questions in the research was, well, what did you do about how did you push back, or how did you deal with the problems that you had at work? And this topic came up. And almost all participants had, expressed a total lack of faith in the BC Human Rights Tribunal, because they saw it as an arm of government kind of risk managing on behalf of public sector employers. So they saw it as ineffective in that they saw that engagement as a total waste of time, because they thought that they would go there and they'll end up getting outed. They'll go through this they'll go through a re-traumatization process in terms of outlining what exactly had happened, and that would prompt the employer to take additional retaliatory measures. So I just wanted to put that out there. And another kind of dimension in the case of those who were directly working for the government. Now, not all of my participants worked for the government. There's another mechanism that is administered through the BC Public Service Agency. And that was also seen, which is kind of like the human resource ministry for the government. And they have these, really fancy wordings and titles for, divisions that will address employee complaints and do investigations and participants in that case as well were very skeptical of the BC Public Service Agency because of the experiences that they had themselves. So they would be made pay for the complaint that they brought up. So they saw complaining about anything to BC Public Service Agency as having career-limiting consequences.
Okay, Vijay, do you like to add anything?
Yeah, I think, accent is kind of tricky too, because sometimes in certain cases you can link it to national origin discrimination, and sometimes it's easier to get, to win those types of cases. But yeah, like I said, sometimes accent gets conflated with like language skills in the workplace, and it becomes something that's, okay, it's not discrimination, it's actually an actual inability to do the job. So it's kind of tricky, yeah.
Okay, I noticed there is a question from Dione Fowler. Dione, would you like to unmute yourself and speak out your question, please?
Sure. So I think I just loved all of these presentations. So thank you all. I have two questions. One for Vijay, and it kind of follows on your last comment, actually. So I love this. I had never really put the accentism in sort of this, the idea of racism. And so I think that actually has reshaped a little bit of the thinking about it for me. But I do have a question about, you know, how it might be within sort of a racialized group, how it might be distinguished, because we can imagine, and again, you kind of touched on this in your last comment, that in some cases accentism could be the reality. So I'm not a racialized person, but I come from a rural area in Western Canada and have changed my accent to sound less lower class or less rural, and also face limitations in terms of political aspirations I had, because I never learned French, and I would never be able to get to a level where I would actually be able to communicate properly to Quebecois. And so I'm just wondering, so there are differences between in some of the cases, but for racialized people, is it possible to even separate that out in your mind? And if so, how would we do that? And then for Kiran and Sheldon, just a question about setting the minimum floor, and you're saying sort of the law might not be enough. What is your perspective on basic income as an alternative way to set that floor, than say a minimum wage or enforcement of minimum standards?
Okay, so I'll go first. Yeah, thank you, Dion, for that question. Yeah, the whole thing with accent and race is kind of, it's complicated, right? For me, there are racial hierarchies with regard to accent. So I'm not saying that white people don't experience accent in their own ways. But within a context where they would be more advantaged than how they speak like, it's really about the perceptions of them as racialized people. So even if just say if I mastered perfect French, so-called perfect French, and I moved to Quebec and I could speak French perfectly, right? Sometimes my racialized body gets perceived as I'm not speaking coherently or intelligibly, right? And just with my past research, I did research with racialized English language teachers. And sometimes these teachers are so-called native English speakers and they have the desired accent for English language teaching, but because of their bodies are perceived as out of place in the Canadian context, for example, they're still perceived as sort of non-native speakers. So I think it's really the short answer is basically it's not really the accent that's always the problem. It's really about the body and the histories that body carries with it. So it's definitely complicated. And I don't think, it's hard to answer within a couple of minutes, but that's what I think.
Okay, Kiran and Sheldon, would you like to address the question, please?
Yes, I could try to answer that question, Dion. Are you, just to paraphrase, are you asking about our thoughts on universal basic income as a minimum floor in regards to employment standards? I'm just wondering if I caught the question correctly.
Yes, precisely.
Okay. Yes. So what I would say is that yes, there's a minimum wage, for example. Yes, universal basic income could help, but I keep thinking, based on our research, that apart from the obvious issues with wages and wage theft and so on, there are other issues that are happening in the workplace that need much more attention. And so, for example, the two examples that we gave with Reina and Jackie, it's really interesting that both of them, two different sectors, complained about the fact that their employer was very verbally aggressive and discriminated against them harshly. So I think the universal, separate and apart from income, there's also this level of workplace harassment that flies under the radar. And in Employment Standards Act, there's nothing that really governs workplace harassment. Workers have to actually go to the tribunal, the human rights tribunal. So while yes, the wages and the income that needs to be addressed, definitely. There are so many different issues that workers face within the workplace, apart from harassment and, for example, not being able to get a record of employment, not being paid vacation pay, and there's so many other challenges and violations that occur. I think the universal basic income would just be taking care of just a small portion of the overall issues that exist within the workplace. So that's why we would argue as well that there needs to be improvements in labor law, the employment standards, and for more coordination between all the acts that protect workers' rights to actually work more in unison to strengthen protections for workers in the workplace, especially those most vulnerable at the lower levels of income.
Okay, so any other questions? So then I have a question for Mia. So about this age discrimination, about the legal measures to prevent age discrimination. So because I paid some attention to the recent European Future of Work study. So one challenge usually being identified for the automation. So there is a debate between automation and aging labor force. So in many automation reports, or to justify the automation or autonomous devices or technology, one would always argue, those industrial groups would argue we have an aging labor force. So that's why the future of European, for example, shipping industry or port industry need to go for fully automation. So in that case, when the port or some other workplace fully adopted this automation techniques, and those age workers will be kind of forced to retire or leave their job. So their jobs no longer existed. So my question is there any current legislation developments trying to protect workers, in particular, both aged workers, senior workers, and junior workers, if their automation is going to be fully developed in their industry?
Yeah. Thank you very much. A very interesting question. I will try to provide a brief answer. Of course, there is a lot of discussion and policy debates about automation, also AI in the workplace, and what are the implications. I don't know of any particular legislative developments in this area. It's complex within the EU to legislate in any area because there are so many different member states and they need to agree. So I think that is perhaps not likely to see in hard law terms, but of course policy discussions are also influential. What we have seen in the area of non-discrimination is that the Court of Justice, so the European Supreme Court, is really the very important actor, because the debates or the conflicts, they give rise to legal discussion in the court. So when the member states cannot agree on new legislation, there are still legal problems that need to be tackled and solved, and that will be done then in the Court of Justice. So I can imagine that we can see further developments in terms of justification for age-related retirements, for example, or dismissals connected to that kind of automation and restructuring. But there are no specific, to my knowledge, legislative responses. But of course, there is in the area of elder law or age discrimination law and policy discussion, great attention being paid to sort of the the understanding of an older worker. So they are both seen as someone who has outdated knowledge, not enough knowledge of technology, etc. At the same time, they have great experience. So there are stereotypes, and then there are individual workers. That is a big challenge. So thank you for your question.
Thank you so much. So we are running out of time. So thank all the presenters for the excellent presentation, and thanks so much for the questions. And I wish you all have a great weekend. And to those in Canada, happy Canada Day. And that's all for our session. Thank you, Jessica, for your technical support.
Thank you so much.
Thanks, everyone. Okay, bye.
Bye-bye.
Bye.